Welcome to the Indian Gaming Association's The New Normal webcast. My name is Lisa Johnson. I'm the conference manager for the Indian Gaming Trade Show and Convention. I'd like to share a few housekeeping tips before we get started. Everyone is muted by default except for our speakers. If you have any questions during the presentation, please type them into the question or chat box and they'll be brought up at the end. The session will also be recorded and available on our website. Now, without further ado, I'd like to introduce Victor Rocha, conference chairman of the Indian Gaming Association.
Yeah, I know, Lisa, we're all doing that too. You know, Glenn, good morning, everyone. I'm Victor Rocha. My co-host is Jason Giles. This is a new normal. Welcome. That's been a big issue. I think we might have touched upon that last time, is that we've changed our name from the National Gaming Association to the Indian Gaming Association, and we all seem to be having problems remembering it, but we will. Good morning, everyone. Good morning, Glenn. Good morning, Jason. Welcome. How are you gentlemen doing? I'd like to preface to say this, first of all, we're very honored to have Glenn, but in order to get him, he's a very busy man, and I promised that I'd keep this thing to 30 minutes. So we're going to jump right into this. Jason, welcome. So let me lay the groundwork. And on June 15th, the Supreme Court resolved long-standing dispute.
Victor's frozen.
Yeah, we lost him, Glenn. So I'll pick it up real quick.
All right.
Coushatta Restoration Act, right?
Yeah,
You froze up there for a minute, Victor.
but we caught Restoration Act, which is the
Oh, okay. Hold on. Let me fix it.
main,
Go ahead. You guys continue, and I'll fix my internet.
All right.
but Glenn, thanks for joining us today. Obviously, you know, you've been at the forefront of Indian gaming for 35 plus years, and you've got a perspective, you know, because you were involved in Cabazon all the way up until now. It's just it's great to have you on and provide us with some context about this Ysleta case. Glenn, if I can, just initially, the ruling only kicks it back to the Fifth Circuit. Is that correct? And is there going to be more? Does there need to be more hearings? Do they have to argue this again in front of the Fifth Circuit? What did they do here?
Yeah. Well, the Supreme Court, by the way, good morning. Thanks to
Right.
both of you for inviting me onto the program. And you're right, old habits die young. It'll be the National Indian Gaming Association for as long as we can do. But that aside, the Supreme Court here overturned two previous rulings by the Fifth Circuit Court of Appeals. And in those rulings, the Fifth Circuit had interpreted this Texas Restoration Act as giving the state of Texas full jurisdiction over tribal gaming activities on those reservations. Stating it another way, you know, the Fifth Circuit said that the Ysleta del Sur Pueblo and the Alabama-Coushatta tribes were subject to the full scope of Texas law and regulation with respect to gaming. The Supreme Court last week, or 10 days ago, overturned that ruling. After 25 years, the Texas tribes had been litigating this for more than 25 years. They finally got to the Supreme Court, and the Supreme Court overturned the rulings of the Fifth Circuit. And I think what they did here, I don't think they had to send it back to the Fifth Circuit. They could have left it the way they you know, with their decision. I think they did it as a matter of courtesy. You know, they're basically saying to the Fifth Circuit, you guys screwed this up pretty badly. We've now told you what the rules and the law are. Now you go back and issue a new opinion that incorporates the ruling that we've made here today. So I think it's really more a matter of courtesy and comedy. I don't think there will be any further hearings in front of the Fifth Circuit. I think the Fifth Circuit's been invited to go back, review and revise the rulings you made in the past and make them consistent with what we, the Supreme Court, are telling you today.
Good. Okay. Well, that makes it clear, because we've been waiting for some direction from the tribe on, you know, what are their next steps and what are they likely to do. But you know, I mean, conceivably they can get a gaming bingo type operation up and running now. Is that right, Glenn?
I would think so. I mean, I think given the Supreme Court's decision, that clearly overturned the earlier Fifth Circuit decisions, I don't think the state of Texas would dare to take any enforcement action if the tribes began doing what the Supreme Court said they're entitled to do. Yeah, they sent it back to the Fifth Circuit for some further, activities, but the ruling is the ruling, and it goes into effect immediately. So I think they would be safe in moving forward if that's what they chose to do.
Okay.
Yeah, I remember when they shut them down in the early 2000s. I remember at the NIGA conference, they had a booth and they were giving out shirts, and they were just really, it was just a really sad day when they had to shut the casino down, and you could see what the ramifications were. And they've been very they've persevered. They've gone other angles. They've turned it into an entertainment center. They've also had a really big push by the state of Texas to keep them in their little box. What does this mean beyond the borders of Texas? I see the big issue here seems to be with the Restoration Act with Texas and the fact that they're under state control. But what does it mean for like some of the other tribes? I mean, it was an issue in Rhode Island, if I remember, for the Narragansetts. It was an issue up in Maine for the tribes up there, which are also state recognized.
Well, the issue in this case was really pretty narrow, really very narrow. Congress in 1986, 6 months after the Cabazon decision came down, had passed a bill restoring the recognition, the federal recognition of these two or three Texas tribes. And as part of that bill, as was often the case in Indian legislation in the 80s, they had to address the issue of gaming. And Congress put some language into this Restoration Act, this 1986 Restoration Act, that dealt with the relationship between the state and the tribes with respect to gaming activities. And to be honest with you, the language wasn't as clear as it could have been. And I guess that's proven by the fact they've been litigating it for 25 years, right? If we had been writing this bill today, we could have made it crystal clear. Congress didn't do that for whatever reason. But they did, but the court looked at the language, looked at the history, and in this case concluded that Congress intended to incorporate the principles from the Cabazon decision into this Texas legislation. And by that I mean that the court found that Congress intended to incorporate the civil regulatory versus criminal prohibitory distinction from Cabazon in this Texas legislation. So big victory for the Texas tribes, but it is a pretty narrow decision. It's not going to have dramatic impact outside of the borders of Texas, except with respect to a couple of things that I'll talk about in a second. But Victor talks about other specific federal legislation dealing with tribes up in the Northeast, in Maine and Rhode Island. And interestingly enough, the court in this case, in the Ysleta del Sur case, goes out of its way to contrast the language that Congress used in this Texas statute versus language Congress used in the Maine and Connecticut statutes, which were adopted around the same time, mid 80s. And what the court said was, in those cases up in the Northeast, Congress clearly intended to make those tribes subject to all state gambling laws, criminal, civil, regulatory, whatever. The language there imposed full state jurisdiction over those tribes up in the Northeast. But the court said, here in Texas, the Congress used different language. It used language different from what used in those other federal enactments. And because of that, we can see clearly that Congress intended to adopt the Cabazon principles in Texas, whereas it did not intend to do that with respect to Maine and Connecticut. So I thought that was pretty interesting that the court looked at those different pieces of legislation dealing with different tribes in different parts of the country and found Congress intended different things based on the language that was used.
And and what's to me also what's interesting is since then, the Maine tribes just recently signed a deal for online mobile sports betting. And the Narragansetts are still, fighting. The last thing I remember, the big deal was they shut down their tobacco shop and the big fight and stuff like that too. And then we also have the Carcieri Act as a part of that too, the history of that. So Jason, what are we looking at here, man? You know what I mean?
Glenn, any chance that the state of Texas pulls Oklahoma and goes back to the Supreme Court and says, pretty please, can you look at this again?
Well, of course they have the right to do that.
Well, Ken Paxton,
frankly,
their AG is crazy.
Yeah, that's true. And they may well do that, given the fact that it's a 5-4 decision. It's a little disturbing. The decision is great. And I want to talk about Justice Gorsuch in a minute, who authored the majority opinion. But after reading it, it's his reasoning is so clear. And the reasoning of the dissent is so obtuse that it's hard for me to understand why this wasn't closer to a unanimous decision. I mean, you're always going to get some people who simply disagree. We've got some folks on the court who simply don't think much about Indian, tribal sovereignty and that sort of thing. But it is a little disturbing to me that this was a 5-4 decision, because I think the law is clearly on the side of the Texas tribes here. And I think Gorsuch makes that plain in his opinion, yet 4 of the justices dissent. So that's a little troubling. Will they go back and ask them to reconsider? Maybe. It won't happen. I mean, they're not going to, they usually take 50 years to overturn a decision, apparently. That seems to be the new rule. So not likely that they would overturn this decision or reconsider it. I think the reasoning is pretty solid.
Well, I mean, this is, we got you on today, and 30 minutes ago, they announced that they, issued a new decision in the previous McGirt case. Oklahoma brought a new case, and the Supreme Court 5-4 with Gorsuch in dissent. They've at least undercut some of their decision from just 2 years ago, and seem to have come more towards the state's way. Just from you, Glenn, because you've practiced and the Supreme Court, it is troubling because we've got a bunch of cases in the pipeline on the federal courts challenging federal Indian laws, whether it's IGRA or Indian Child Welfare Act, as race-based laws that should be struck down because they're race-based and provide an unfair race advantage towards Indians, which is, we thought that was settled, back Morton v. Mancari, and it's just kind of scary right now because you don't know what these people are up to, they're clearly just ready to throw out Roe, and who knows what else is next. But
Dred Scott.
Dred Scott, they're going to
they're going for Dred Scott.
Okay, but it's a little frightening. I mean, any suggestions out there from a litigator? If you're a tribe and you're dealing with cross-jurisdictional issues, tribal governments and working with their county and state governments can maybe head some of this off if they reach agreements. What do you think, Glenn? I mean,
yeah, well, I haven't seen the latest Oklahoma decision that just came down. Obviously, we'll all take a look at it when we get off this program. And I understood that Oklahoma had been filing petition after petition asking the court. I mean, the court. Look, I hope I'm not wrong here. I hope I'm not going out on a limb, but I doubt they reversed McGirt completely. I think what they've, more likely they've nibbled around the edges of it, having to do with some jurisdictional issues that have arisen as a result of McGirt. But, my understanding is that while some people like the governor of Oklahoma have been running around with his hair on fire, this is a complete disaster, criminals are being released, laws aren't being enforced. I've heard quite the opposite. I've heard that the tribes and the local governments are working pretty well together. Sure, the McGirt decision was a big deal, a real big deal. And it requires some changes in how things were done out there, in how prosecutions were conducted and where they were conducted, that sort of thing. But I understand that the tribes and the tribes and the local governments, at least, are working pretty well together to solve the problems and find ways to prosecute crooks and criminals, get them off the streets, and do it in a way that preserves tribal sovereignty, but allows the state some authority to engage in certain activities, certain law enforcement activities. So I'll be interested to see what the court did this morning. I'm troubled that I hear that Gorsuch is in the dissent. That is not.
No, that's good. Because he chastised the other 5 and said, we just ruled on this, and you guys are. And in the dissent, I haven't read the opinion either. This was just in the media articles, but he said that the majority is caving to a social media campaign by the state of Oklahoma. And,
right. And it's also an election year too. It's also an election year too. You know what I mean? So this is a big issue in Texas. It's a big cudgel. You know,
Supreme should never matter for the Supreme Court, but clearly when you just jam 3 of them on and Merrick Garland never gets a hearing, and this is, and they're leaking, getting draft opinions leaked. This Supreme Court seems just a little bit, more political than ever. And I know it's been political in the past, but we've never lived through it until now.
It does, but let me say this, and this is a point I wanted to make. I think we have to keep our eye on Justice Gorsuch. For decades, tribes have not had a champion on the court. Back in the 70s and 80s, we had Justices Marshall and Brennan. And, when Indian law cases came before the court, when they were on the court, you could almost count on their votes. I mean, they really understood tribal sovereignty. They supported tribal sovereignty. They were advocates of expanding tribal sovereignty in many cases. So we had, Indian country had advocates on the court, champions on the court. When those 2 left, and I don't remember when it was, probably the early 90s, until very recently, we haven't had anybody on the court who either understood federal Indian law, or B, cared about federal Indian law, or 3, had any great sympathies for tribes and tribal sovereignty. And as a result, we suffered pretty significantly during those decades with some pretty bad decisions on Indian law issues. I think, I don't want to overstate this, and I'm not sure yet, but I'm beginning to think that Gorsuch is going to be a breath of fresh air for Indian country. Conservative Republican, no doubt about it, but he comes from Colorado. He served on the 10th Circuit Court of Appeals, which hears lots of Indian law cases, probably second to the 9th Circuit. And he clearly understands this stuff. And I'm beginning to think, maybe irrationally, but I'm hopeful at least, that Gorsuch is going to turn into a guy who not only understands federal Indian law and tribal interest, but is willing to step out and protect those principles. Look, he authored McGirt and got terrible. It is true, he got terrible. He got attacked terribly in social media. Not only in Oklahoma. I mean, I don't know if you guys read, the Wall Street Journal has been on a tirade against McGirt. The Wall Street Journal must have had 4 or 5 editorials about the McGirt opinion over the last couple of years. But Gorsuch authored that opinion. It was well reasoned. He said, look, the United States made a promise to these tribes, and until Congress does something to break that promise, they're entitled to the benefits of that promise. And similarly in Ysleta del Sur, Gorsuch is the author. Now, again, it's a 5-4 decision. It's not unanimous by a long shot, but Gorsuch clearly understood the principles that the court was establishing in Cabazon, important principles, and didn't hesitate to find that those principles had been incorporated into this Texas Restoration Act. So, 2 opinions do not a record make, but nevertheless, I'm hopeful that we're going to see Gorsuch as a guy who understands Indian law and is willing to preserve and protect concepts of tribal sovereignty in a way that we haven't really seen on the court in quite a long time.
Great. Well, one other thing. So looking down the line here, Glenn, so how does this play out? Does it have, positive implications for tribes in other states, say California, just in the general body of Indian law? Is this, like you said, just was a narrow thing dealing with that Restoration Act in Texas?
Yeah, I don't see Ysleta del Sur as again, real important for those tribes. It puts them on a path to, to some economic benefits that they've been denied unlawfully for decades. So real important for those tribes. Beyond that, probably not much of an impact. I know in the oral argument, after this case was argued, I didn't listen to the oral argument, but after it was argued, I got calls from several people saying, "My God, they're talking about overturning Cabazon. Did you hear about this?" They were, So I went and actually listened to the argument. That I listened to a recording of the argument, and yes, in the context of oral argument, justices acting as devil's advocates often suggest extreme positions to try to test the lawyer's commitment to their arguments. And yes, somebody in the, one of the justices said something offhand like, well, maybe we ought to reconsider, somebody was questioning whether the Cabazon principles were workable. And one of the justices said something, well, maybe we ought to go back and reconsider Cabazon then if it's not a workable standard. I took that as not a serious suggestion. So it's heartening to the Cabazon band, I can tell you that this case, this very recent case, reaffirms the Cabazon principles. No one in this case, including the dissent, raised any serious question about the Cabazon result. In fact, even the dissent, who would have held that the tribes were subject to all of Texas state laws and regulations, even the dissent didn't really question the holding in Cabazon. In fact, they barely talked about it. From their point of view, it was a question of legislative interpretation, not really a question of did Cabazon, was the Cabazon case rightly decided? So I think, from that point of view, we take a lot of pleasure in the fact that the court here has reaffirmed the Cabazon principles, found them to be workable and applicable to these Texas tribes. But I don't think that Ysleta del Sur is going to have much national impact. I think some of the cases you mentioned, Jason, that are coming up in the pipeline are more likely, depending on how they go, more likely to have a bigger impact in Indian country than this one. But I don't want to downplay it. Look, right. When we win in the Supreme Court, it's a big deal. It doesn't matter if it's a big case or a small case. You take these victories and you run with them. So it's a great day to win a case in the Supreme Court. Now we have to look and see what they did in this Oklahoma case. Things aren't going to be rosy in every situation. But the fact that we've got a good win here in Ysleta del Sur is something that I think Indian country can take a lot of satisfaction in.
As a non-lawyer, and as I told you before, I'm a lawyer like George Costanza is an architect. And, but one of the interesting things was during oral arguments, they started talking about bingo and bingo machines. And then one of the big arguments was the fact that bingo isn't what it used to be. And then they mentioned there were some jokes about the dog and stuff like that. But the core of it was the fact that the technology has sped up the game. And the argument was, well, that's not the bingo that it used to be. It's different. But it seems, one of the things that I noticed as an observer is that the court does leave breadcrumbs for later on down the road. And this seemed to me like a big breadcrumb.
Well, I think you may be right, Victor. I mean, interestingly enough, the dissent included in their dissenting opinion a photograph of the electronic bingo machines that are at issue here. Here's the last page of the dissent. You can't see it, but take my word for it. It's a picture of electronic bingo machines. And the dissent does make something out of the fact that this isn't your church basement bingo. So might that issue come back as the next step in the Texas litigation? I think it's possible. If they play these devices, which they are entitled to, I wouldn't doubt that the state of California, the state of Texas might go in, and the next case is going to be this is illegal Class 3 gaming. These aren't bingo machines; these are slot machines. The same sort of cases we've seen around the country years ago. I mean, those issues are now pretty well resolved in the rest of the country. But Texas is Texas, and they may decide to relitigate those cases all over again. I wouldn't be surprised at all.
No, that's something to look out for. That's a good observation, Glenn. I don't usually read the dissents. That's why I missed that picture.
I did, and let me tell you, the reasoning I thought was really bad. I mean, the Chief Justice Roberts, who's a very smart guy and a very good lawyer. I mean, politics aside, the guy's no dummy. But this opinion really, I thought, was not very well reasoned. I mean, I think he ignored most of many of the arguments that the majority had made, and just sort of focused on one or two narrow issues that I don't think really made the case very effectively for him. So I thought the majority opinion by Gorsuch was very well reasoned. I thought the dissent, and sometimes the dissent makes good points. Look, when a case gets to the Supreme Court, they're usually pretty close cases. They're usually not slam dunks one way or the other. There's pretty good arguments on both sides. In this case, I didn't think the dissent's position was particularly strong. I thought the dissent was unusually weak and didn't really address most of the issues that the majority had raised. But my point was, I usually read the dissents. that was my point. I usually read the dissents, not because they're the law, but you want to see how the other side reacted to the facts and the presentation that had been made there. So it's sometimes interesting.
Yeah, Jason.
Well, we'll find out keep an eye on Trump's criminal case and how the Supreme Court ultimately deals with that. Real clear picture.
well, listen, in keeping with my promise with Glenn and getting him out here, we need to wrap this up because first of all, Glenn, really thank you so much for coming. This was a fascinating case on so many different levels. And for me, again, as a non-lawyer, it kind of reinforced that if the state can do it, the tribe can do it. And it seemed to, and that's a really big issue. And I think with Texas too, they're on the fast track to getting gaming too. So even if they go at Class 3 is going to be legal there pretty soon within the next couple of years. So I think it's probably just a waste of time unless they want to be vindictive, which is also in the repertoire, and they could do that also. So they got nothing better to do other than, it's Texas. So
how would you like to have to negotiate a Class 3 compact with the Attorney General of Texas? There's a lifetime commitment for you.
Oh my gosh, I can't even imagine. It's got to be this. I would hire somebody from Oklahoma, and then I would send them over to Texas. So Jason, I think, are we done, my friend?
Yeah, Victor. Glenn, thank you for your time. I know, you're still working hard out there and doing your thing on behalf of tribes, and we appreciate, attorneys like yourself that are in the trenches on this for 30, 40 plus years, and just defending tribal sovereignty was what it comes down to. And it's a little bit of scary times. I'll just say that, that Maverick case in Washington State, Glenn.
Yeah.
The only thing that worries me there is they have Ted Olson as the lead counsel. And why he would, I'm sure the gaming companies went to him and said, here's tens of millions of dollars. And because you don't have a shot unless you've got a name attached to it. And he's a name, and they know him at the Supreme Court. So, here we go again. I think the state of Washington's handled it great so far, and the tribes have not intervened yet because it should be thrown out, the second it gets to the judge's desk. And it probably will be, but they're going to appeal it all the way up. So,
you're right though. There are some scary cases out there that we've got to keep a close watch on. You can't become complacent, even when you win one, like the Texas tribes did the other day. You can't become complacent because there's always another one coming through the pipeline. So let's all keep our eyes and ears open on this stuff.
Yep. And Well, Glenn, thank you. Jason, thank you. Just let everybody know I'm going to be out of town for the next couple weeks, but we'll be back when I was done. Also, I noticed there was a question from Joseph Harrigan. Actually, it was more of a comment saying the Alabama-Coushatta has a favorable district court decision finding that its machines do play the game of bingo. Texas's appeal was stayed pending the Supreme Court decision.
All right. So
they got
the issue is being litigated. All right.
Texas.
Thank you, Joseph. Yeah.
Thank you, Glenn. Thank you, Jason. Thank you, everyone. We'll see you guys in 3 weeks. We'll be back with something really important and current. So thanks, everyone. See you soon. Bye.
See everyone in Oklahoma. Bye.
Thank you.